Gumshoes. Sorry, I'm a couple minutes late. One of my kids had a small crisis because adulting isn't easy. So I'm just going to give it a minute to confirm that we have sound, and then we will go ahead and get started. Let me check here. I'm not hearing it on my end. Okay, there we go. We're good. Okay, so tonight, I had just said, like, I do not see myself as a reporter on this case. I'm not trying to be a reporter on this case. I'm not trying to bring the late breaking news. I'm really more of an analyst. So I'm looking for things that are interesting, that tie in to the timeline, or, you know, that just kind of jump out at me. And so this past week, I was listening to the two most recent hearings, so the pretrial conference and the status hearing or conference, whatever it's called. And there were a lot of really interesting details. Now, I'm going to somewhat go chronologically through them. So I'm going to start with the February 27th pretrial conference, and then move to the March 2nd status hearing. And at the very end, it gets a little dicey because, as I mentioned in the description, and if you follow Cool Cats or the community tab, mistakes have been made. And you know, I kind of went back and forth on whether to even talk about it, but I think at this next hearing, things could get a little heated, not so much in the hearing, but afterwards. And so I just thought, you know what, I want to kind of get in front of this, and for whatever it's worth, just present my perspective on this, because I do think that we need to keep things in perspective. I also, before doing this hearing, I'm going to pull up my notes here. I talked to a friend of mine who's a judge, because I was actually going to go live this weekend, and I thought, no, I want to talk to this friend first, just to make sure that I'm understanding some of the implications of some of these developments, that they don't look very good, but because of that, I mean, like, let me just say from the outset, I don't think either of the cases is in jeopardy. I think that justice will be served. I'm not an optimist. I'm also not a pessimist. I'm very much a realist. So I'm just looking at all of the facts, and even, you know, details that I was able to, you know, kind of run by my friends, and so I felt that much more confidence that justice will be served. It's going to be a little bit of a bumpy ride, but I do believe that justice will be served. So I'm just going to say that from the outset, I absolutely do not believe that either of the cases is in any kind of jeopardy. So having said that, I am going to jump in to the February 27th pretrial conference, as I mentioned. We're going to, so a couple, I kind of broke out like Lori's defense and Chad's defense, because in both of these hearings, obviously this was a pretrial conference, and the status hearing, or status conference. And, you know, so obviously both defense attorneys were represented. And so for the first one, I'm going to break it out into Lori's defense. There were a couple points that Jim Archibald made that were interesting to me. One thing I will say about Jim Archibald is, and I've already sung his praises before, I think he's an excellent attorney. I've been very impressed with him for whatever that's worth. But, he just kind of, he rocks his like Atticus vibe. If you're at all familiar with, oh my gosh, what's the name? I'm blanking on the To Kill a Mockingbird. It was one of my favorite stories. And, he's just very, very calm, cool, collected. He's really just everything the opposite of John Pryor. And but there is a point in the March 2nd conference where he wasn't so calm, cool, and collected. And you'll see how that gets the judge's attention, because Pryor is the quintessential boy who cried wolf. He's just always crying wolf. He's always going to the worst possible conclusion. Like everyone is just picking on him, and he says some very cringy things in both of these hearings, and we will touch on them. But Jim Archibald, he chooses his words very carefully. Emotionally, he's very metered. And I think he will wage an excellent defense. So anytime he makes a point that is like salient, I'm like, oh, ouch. Okay, that's a really good point. But it's good because there's no way at this point, I mean, anything is possible, but I do not see Lori getting a potential appeal based on inadequate counsel. He's very, very adequate. So I was very impressed. I've also, again, for whatever it's worth, I was also really impressed in both of these hearings with Lindsay Blake and with Judge Boyce. Like both of them were relatively new in their positions when this, this case fell into their lap. And, so understandably, any of us, when we're new at something, like we're a little nervous, a little apprehensive. But I really felt like both of them really filled out their role. Like I was especially impressed with Judge Boyce in both of these hearings. Now, I disagree with him passionately on the point of removing cameras from the courtroom. I've said that before. I do not think this is what progress looks like, and lots of trials have been able to successfully be carried out long before even social media and stuff. So that I will always go tete-a-tete with him on. I just don't think like this is what transparency looks like, especially in 2023. However, I don't ever want like one opinion to then like overshadow other opinions. And I have to say, the way he conducted himself, the way he, kind of went with the ebb and flow. And I mean, there were some big surprises in the second hearing, especially. And anyway, so for whatever it's worth, I was just really impressed with both of them. So, okay, having said all that, I am going to share my screen and we will get started. Okay, so the first point that I thought was interesting that Jim Archibald made was that he drew a line in the sand and said that he does not plan to present a mental health argument in the guilt phase of the trial. He only intends to present that if Lori is convicted. So we'll listen to that.
And so in our mental health assessments, all the mental health experts that have evaluated her from the state hospital to our experts say, yes, she does have a mental illness. There's no question. And however, since she's never said in in here or anywhere, since she's never said, I did it, but I was crazy, then 18207 doesn't apply. So that's why the mental health evidence that we intend to present is if she's convicted. She believes that she will not be convicted, and so the mental health evidence should never be presented.
Okay. I mean, what Lori believes is going to happen is pretty immaterial. But I thought that was interesting, and he was trying to get the state to similarly say they are not going to present an argument about mental health. So there was some back and forth on that. I also thought it was interesting that he said that she has never had basically an excited utterance or otherwise, like she's never said, okay, I did it, but I was crazy. Because I know that there was a rumor back when she was found incompetent, and this is part of the reason I just don't share rumors. Like I really, even in this other timeline that I keep that has some details that haven't been confirmed yet. Some I've shared before they were confirmed, only because the source was so trustworthy. I mean, I still am just very, very clear, or I try to always be very clear. This is coming from a confidential source. This has not been confirmed in the FOIA docs, or it has been confirmed in the FOIA docs and stuff. But there are details that they just, they're how do I put it? There's too much gravitas to them to share without some kind of confirmation. And so, there is one person that I share these details with, and that's just more so that I don't have to tell people oh, take my word for it, this detail was shared with me, or whatever. But so having said that, there was a detail when Lori was first found incompetent to stand trial, a rumor that she was yelling out from her jail cell, he made me do it, and yada yada. And that's why it was said that she wasn't able to assist in her own defense. So I've always just kind of held that in the back of my mind, maybe. But since I do believe that she has mental illness, but I've never believed that it was to the point of being incompetent to stand trial. So I don't really see her yelling something like that out of a jail cell. So, take that for what it's worth from both, Mr. Archibald and from me. But I just thought that was interesting. In my mind, it, somewhat puts to bed that that rumor. It doesn't completely rule it out because, he was, he may or may not have been privy to some of those details. Anyway, just so I throw it out there. Okay. Next up, this was a relatively minor point, but it really stood out to me. He made a point that they will be calling very few witnesses.
And so it sounds like they're conceding that they're not going to call him during their case in chief. And so I appreciate knowing that. And we certainly don't intend to open the door because our witnesses will be very few during the guilt phase.
So the guilt phase is the main trial. But I just thought that was interesting. I mean, it basically sounds like there is no one willing. I mean, not no one, but there aren't very many people who are probably willing to say much in her defense. I just thought that was an interesting point. Because, they could also be calling, professionals from, forensic professionals, all kinds of different witnesses. I know that John Pryor is planning, or he has mentioned multiple witnesses, but Jim Archibald is just kind of like, yeah, we're not calling very many. Okay. All right. There were multiple times where, in my opinion, John Pryor really embarrassed himself, especially in the pretrial conference. And I will point out some of those. I still want to be fair. I do just find his approach so unsavory, and I think it works against him. I think, he, like I said, he cries wolf so many times that, like, there was one point where the judge, who is also very, very metered in his responses, he actually said something to the effect of, I know that you've said over and over, and then he said what he said. And so I thought, oh, word? Like, that was a very, very subtle burn, but he was right. Like, John, there's this, I referenced this before, and I'm going to butcher it, I'm sure, but there's this legal adage, like, if you have facts on your side, pound the facts. If you have the law on your side, pound the law. If you have neither facts nor the law on your side, pound the table. And I just find him to be like the quintessential table pounder. Even when he does have facts or the law on his side, which we'll see in the second hearing, I actually suspect that he and Jim Archibald talked ahead of time, and Jim said, hey, let me handle this one. I could be wrong. I'll share why I think that when we get to those video snippets. But I think had Pryor presented this, this issue, it would have probably had a very different effect, because he goes on and on and on. He cries foul, way too much. And you'll see how exaggerated some of these allegations that he makes are. And anyway, so we will start with his assertion. He was talking about how there was 12 terabytes of data that the prosecution had. Now, we already know, if you follow the community tab or Cool Cats, I've talked about this, that the prosecutor, Lindsay Blake, had pointed out in one of her filings that, or we don't know who it was. It could have been, it came jointly from Lindsay Blake and Rob Wood. But their point was Pryor has had 2 years to collect the evidence gathered from the devices that were acquired via a search warrant in January 2020, when they did a search of Chad's home. There were quite a few devices, there were journals, and so they had made the point that although he's had almost 2 years, he still to the date of that filing had not requested them. So he is making the case that it's 12 terabytes of data. And this is what he says.
Given the fact the state did notice in their inventory some of the electronic devices, they itemized some of the electronic devices. And then what they did, Judge, is they've obviously downloaded all of that information. 12 terabytes of information. Now, 12 terabytes would fit in the back of a cargo van. That's how much evidence is 12 terabytes of information.
Okay. I don't know if this guy is completely clueless about all things tech, or if he is intentionally being deceptive. But his point about it would fill the back of a cargo van, and later he says it would fill the back of a truck. But that's just not true. So I did a simple search on Amazon. I threw out a picture of this is just an external hard drive. I threw a picture out of one on the community tab this weekend, and also in Cool Cats, and made the point, it's 3 pounds. So sure, you could throw it in the back of a cargo van, but you could also just put it in a briefcase. But then I found one that is 1.5 pounds on Amazon. So down here it has like more details, and let's see somewhere. Yeah. Item weight, 1.4 pounds. So, I mean, it's just so ridiculous. Like the fact that he's like, oh, this, if I were to go there and collect this, this information, this data, I'd basically need to rent a cargo van and pick it up. Like, yeah, if it were 1978, sure, but we're not dealing with floppy disks and, and analog here. Everything is digital. And so, and he also said, which you'll see in this next video, where I was really impressed. Judge Boyce did address him and did counter his argument. But he says, I think it's in this snippet, he said that, if he were to, go and download this information, it would take a week and a half to download. Again, either completely out of touch or just unethical and just willing to lie, because the guy could have handed over his external hard drive, gone. I made this point over the weekend. He could have gotten a cheeseburger, come back and picked it up. It's just ridiculous for him to assert it would take a week and a half. He was also describing that he would have to, go there and stay there, for a week and a half, 2 weeks. And I think he even made it longer, to be able to look at all of this information. And it was just completely out of scope. He was like a tantruming child who is just so emotional that you just can't even reason with him. And so let's listen to that.
The chain of custody was just provided to me 2 days ago. The 12 terabytes has not been provided to me. And if the court wants to insist that, maybe I should have gone down to the prosecutor's office and spent a week and a half waiting for them to download, they do not get to sit there and make my job more difficult, because they obtained evidence and confiscated evidence and then said, hey, guess what? There's a lot here. You guys have to go and provide it at your own expense and go down to do that. That's not what the intent was of being able to examine. Judge, I could spend 3 months in front of their office examining these devices. You do not get to make my life more difficult to do that. They have to provide it.
Devices, Mr. Pryor, that is the standard way things work. When the state has evidence, it keeps the evidence in its custody, and defense is allowed to review the evidence. And if you were provided an opportunity to review those electronic devices and didn't go do that before now, as long as you were given access to the devices, then that's how evidence works. Evidence doesn't just start floating around to defense attorneys out of the state's custody. And I see the state's point on that if it was made accessible to you. Now, if you're telling me they wouldn't provide you access or didn't tell you they had it, that's a different story. But I think on those electronic devices, that puts the burden on you to go see what they've got and review the evidence there, and they're not going to release it to you.
So again, I was really impressed with Judge Boyce, really just kind of going mano a mano with Pryor over that point. Now, to push this point to quite possibly a breaking point, but I don't think so. A normal person in this scenario who had even a modicum of understanding of how technology works would say, okay, I need, it's 12 terabytes, that's why I pulled up 14 terabytes, because the hard drive itself has some software on it, so you want to have a little bit of buffer. But you just go to Amazon, or your favorite, website, and just order it. This is how John Pryor describes the trauma of having to secure this device.
Now, for the record, I provided the state's support staff a 16 terabyte hard drive. This isn't something, Judge, that I can go to Walmart or to Office Depot or Staples or anything like that. Not possible. You can't buy it in a store, and I went to 3 or 4 stores trying to find a large enough external hard drive to accommodate that information. And last week, or a week and a half ago, last week, I believe, the state notified me it's 12 terabytes. So I had to order it special and have it delivered. And once it arrived, I then was able to deliver it to them today for them to start the process of downloading 12 terabytes of evidence.
It's just so ridiculous. Do I believe he went to 3 or 4 stores before ordering it most likely from Amazon? No, I'm not inclined to believe that. It's so ridiculous. Like, we're talking economy of effort here. Like, why would you go around to 3 to 4 stores when Amazon is pretty ubiquitous at this point? He lives in a capital city. So it's not even like he lives in, like Rexburg, where, having found out from Janice how long, deliveries sometimes take to get there. I was really surprised because obviously we don't have that issue where I live. But I mean, he lives in a capital city. It would be like a day or two. So, his exaggeration of the effort and the cost. I mean, come on, $200. I mean, that in the business world, that's called cost of doing business. Like, surely this is not the first case you've had where you've had to get an external hard drive. This is not difficult. And he had almost 2 years to do it. So this is typical John Pryor, just throw a complete, hissy fit in hopes that the court will somehow be manipulated into thinking like, wow, I can see just, what a burden this must be for you. We should go ahead and sever these cases. Now, obviously, the judge did decide to sever the cases, but it wasn't because of this. Okay. All right. Another point that he made that was exaggerated is he was talking about the GPS data. And there were a couple issues with this, but I'll address this one first. We'll just go ahead and listen to the video.
So in the last month, even though they've had a preliminary hearing on the original charge, where their expert got up there and talked about waypoints 3 years ago, and then they have a grand jury proceeding, and there's discussion about that as well. And then suddenly now in February, after all of these steps, they provide me 500,000 waypoints that I'm supposed to process. And I didn't hear an explanation as to why they mishandled the evidence. I didn't hear an explanation as to why they weren't able to provide me all the evidence. What they did provide is an explanation saying, well, we just discovered that, oh, by the way, we didn't give you all the evidence in a capital murder case. We've just discovered that oops, sorry, but here it is now, and you're supposed to be ready. I'm sorry we didn't get it to you in time.
Okay, so on this point, I'm not sure if I'm missing something, so I'm just going to present, what I know from, kind of going through some of these discovery details. Okay, so this was dated the 27th of October, this past year, 2022. You can see here under documents and tangible objects, it says, in addition to the above, the state may also utilize the following as evidence at the trial, all of which has either previously been provided or is attached here too. Combined final cast report. So the cast report, I included this in the 4 questions that the GPS data might answer live that I did. But And so when you see cast, is the GPS data. Combined final cast report, October 20th, 2022. And this was provided on a thumb drive. So John Pryor was saying that he didn't get this until February. Even if that's true, all the discovery was due before the pretrial conference on February 27th. So the fact that he was talking about it at all in the past tense, it was February 27th. So everything, all of the discovery was due by February 26th. So, I mean, even if they had gotten it to him, like the day before, that would have been fair. But it looks to me like, in addition to what was already provided, and we know that some cast data was already provided because it was included in Chad's pretrial hearing, which he referred to. So he keeps like conflating details. Like he will share a detail that clearly establishes that the state did their due diligence, but try to put it in such a way to victimize himself. And it happens again and again. And if, God forbid, anything, it does go amok in the trial, I think that this will really disserve John Pryor, because now he's not going to have Jim Archibald to, run interference and to get the judge's attention, because he doesn't play these childish games. So anyway, I'm going to go ahead and call foul on this claim and move on. Okay. Let's see. Oh, also, he talked about the waypoints. So with GPS data, you have at every point, where someone is. So if I'm in my home has a latitude value and a longitude value. And so then if I were to move, let's say 100 yards away from my home, and I have an electronic device with the GPS, and the GPS is on, which, most of them have it on by default, then I'm going to have a new latitude and longitude point. And so if someone is on the move, you could easily, especially with multiple people with, multiple devices and burner phones, it makes sense that there could be 500,000, waypoints, or like those combinations of the latitude and longitude. But he makes it sound like now he's going to have to manually rifle through 500,000 data points, which is absurd, because if he doesn't know how to do this, then he needs to hire someone to do it. But you just take this data and you put it into a GPS visualization tool. There are multiple tools on the market, and because of that, they're affordable. But you just put it in a data visualization tool, and then you see these data points, but they're on a map. I mean, you could even work with like the Google Maps API and some of the tools do. So it's a very straightforward process. Now, if you're talking about, okay, well then that generates, multiple maps because they were on the move, so they were in Idaho, they were in Arizona, they were in Utah, so we don't know, which of these data points are particularly, I don't know, have evidentiary value, I guess you could say. But certainly, if he doesn't know how to do this, then he could hand this over to someone who does, who would just generate a report, and he would have to interpret the report. But he continually makes it sound like his job is so much harder than it is. And his job is hard. I mean, he is having to defend someone who was allegedly a very unsophisticated criminal and he had, co-conspirators who were also unsophisticated, unintelligent. So there's no doubt that John Pryor's job is very difficult, but he signed up for it. He's not like Jim Archibald where it was assigned to him, So anyway, I just grow up, do your job, and move on. Okay. All right. This was, in my opinion, the cringiest moment. It needs no introduction.
Now, at this point, Judge, they should have been providing me a copy of all of the evidence. And in those journals, those 26 journals include journals of some of his children.
Whoop, excuse me. This one.
And Mr. Daybell has the right to effective assistance of counsel. He's chosen me to do this, and he's repeatedly expressed his pleasure in the job that I'm doing. And I think he would say that today.
Dude, come on. Read the room. I am confident there is no one in that room who cared one iota about Chad's pleasure. Maybe Lori, but nobody cares, so first of all, it's self-congratulatory. And secondly, it's just so cringy. He's making the point that, that Chad has a right to effective counsel. Okay, I'll give him that point. But then to say, he's expressed, multiple times his pleasure in the job I'm doing, just cringy. Anyway, okay. All right, so now to move on to some of the evidence that was presented in the pretrial conference. I thought this was interesting, that when they, executed the search warrant on Chad Daybell's home in January 2020, in addition to all of the electronic devices they gathered, which also includes electronic devices belonging to his kids. And so I talked about this on the community tab as well as in Cool Cats, that they have a phone and an iPad belonging to Seth and his wife. So I don't know if they turned them over voluntarily or I can't imagine that I don't know, maybe they told them leave all your electronic devices here. I just don't know, but I thought that was interesting. But in addition to the electronic devices, they collected 26 journals, some of which belong to his kids.
Now, at this point, Judge, they should have been providing me a copy of all of the evidence. And in those journals, those 26 journals include journals of some of his children. And I would challenge any one of us to say, we know exactly what's in every single page of our children's journals. I would suggest, Judge, I don't know what's in any of my children's journals. Maybe I'd be surprised. Maybe I'd be shocked at what some of my children are saying about me. But Mr. Daybell has no idea what's in the 26 journals.
Yeah, maybe you would. But on a serious note, I felt for his kids. I hope that they will exercise a great deal of discretion before just, sharing details from their personal journals. I'm sure they would, but I really felt for them. I remember way back in the day keeping journals myself. I just can't imagine. I mean, just because they're so private, you don't think that one day law enforcement will, come into your home and collect your journals. So, okay. All right. In reference to the DNA that was collected, so they talked a little bit about this in another live. When they tested the DNA that they had, they found additional hairs. They were small and somewhat compromised. I also found out in these hearings that the hairs didn't include the roots, which is where they get, I think, the mitochondrial DNA. I'm not really sure about that, but it's where they get some of the DNA evidence. So Lindsay Blake had made the point that the lab said that they don't have the resources to be able to extract a DNA profile, and then they send it to another lab, and that lab, according to Ms. Blake, said that it was very unlikely that they would be able to extract a DNA profile from this DNA. Well, understandably, John Pryor's point was, I want to test it myself. I want to have my own experts test it. And that was the point that the two trials, eventually, or the two cases eventually were severed. But I thought it was interesting that in the pretrial conference, Pryor had made the point that he was almost certain that the DNA evidence would be exculpatory.
As far as the DNA evidence, that's the only step I think is going to be that I'm almost certain is exculpatory evidence. The rest of it I don't know yet because I haven't had a chance to go through it.
Okay, the rest of the evidence, like the judge had already made the point. You've had plenty of opportunity. This is the way evidence works. But I just thought it was interesting that he's going to say whatever he needs to say to get these cases severed. I mean, this is what he's been gunning for a long time. But so does that mean anything? Probably not. I think even by saying almost certain, he's like, well, I don't know how much my client has lied to me. Because if you think back to the pretrial conference, I thought it was interesting that when Melanie Gibb was testifying about their little field trip to the property, she had said that she was also on that trip. And you can see like Pryor's hackles kind of go up, like, oh, really? That's surprising to me. I didn't know that. And then Chad just like looks down, and he just keeps looking down the entire time. I mean, he is also a bit of an automaton, so he doesn't show a whole lot of, emotion or expression, but you do see at times him cringe. And in my opinion, that was one of those times. So I don't think that Chad had told him, and just everyone who was there on that trip. And, so maybe that's part of the reason that he said, he was almost certain. Okay. Anyway, another interesting point was Lindsay Blake had said, basically, the defense could have tested the DNA at any time. Let's listen to that.
The state didn't have an obligation to have this evidence tested. The defense at any point could have called the state lab in the last 2 years. They could have called, they could have asked to go review the evidence. They could have done something, they could have pushed the state lab, they could have made calls to them. There was no restriction on the defense contacting the state lab. There was no restriction on the defense going in to observe those materials. The defense chose not to. For whatever strategic purpose, trial strategy, whether that's to get us where we are today or otherwise, that was a strategic decision made by defense counsel to not follow up on that.
Okay, so I thought that was interesting. Like, okay, so obviously the defense, he's quibbling over a $200 external hard drive. So clearly they're not going to absorb the cost of DNA testing. Also, he wouldn't have been motivated to do that, because as long as we had this protracted delay in getting the DNA, tests run, his chances of having these cases severed increased, so, and I did ask my friend about that, like, did they really not have a responsibility to test the DNA? Like, I can understand her point about the defense could have done it, but I couldn't, it didn't really make sense to me that when she said like they didn't have to test the DNA. And so my friend had made the point that it's a recoverable claim. Like if the lab had said, hey, with all of the DNA evidence, we're most likely not going to be able to recover profiles. She said that that's a recoverable claim because an expert told them that they won't be able to get anything from that. But if there was a discovery request and they had the DNA tested, they would have to pass that on. And also anything that's potentially exculpatory, which she said, a lot of times DNA, the defense wants, that's what the defense wants. They want DNA to be exculpatory. You don't see Jim Archibald, he doesn't really have a horse in this race with the DNA. In fact, there was one point where Lindsay Blake said that she reached out to both defense counsel about the additional hairs, and they didn't even hear back from Jim Archibald. And so I thought that was interesting because it just kind of seems like he's like, yeah, I'm not really hopeful that any DNA is going to be exculpatory for my client. So he just didn't have a whole lot to say about the DNA. And I thought it was interesting, if true, that he didn't even reply to the email. But yeah, so, my friend was very hesitant because, she doesn't have all of the details. And since all of this is obviously outside my wheelhouse, there could be details that I was missing. But she said, typically that would be considered due diligence to have DNA tested. So that might have been a little bit of hyperbole, but at the same time, there could also be, some inference that she wasn't aware of, that I wasn't aware of, to pass on to her. So, okay. Next point. Lost my notes here. So John Pryor made the point that the prosecution has secured hair samples from multiple people. So let's listen to that.
And the reality is this, is that they have hair samples from a number of people. They've taken hair samples from Mr. Daybell, they've taken hair samples from Ms. Vallow, and I'm not going to mention the number of other people that they've taken hair samples from. I want to know whose hairs they are. Because if there are hairs that are found on a piece of evidence, and they don't belong to Mr. Daybell, I want to know. I don't want just a profile saying, oh, by the way, it's a male or it's a female. This is what we think. I want confirmation. And on top of that, Judge, if it comes back and it identifies somebody, I want my lab to be able to go through, and I want Dr. Hempinkian, who I'm not bolstering him, but from my perspective, the best of the best. And Dr. Hempinkian gets a right to review all the evidence and make an independent determination.
So he couldn't have made that point about having his expert review the evidence. He couldn't have made that any more awkwardly, but it is true, and you'll see. Well, I can't say it's true. Judge Boyce agreed with him, as we'll see in the next hearing. Okay, so that wraps up what I thought were interesting points from the pretrial conference. Now we're going to move forward to the March 2nd status conference. This is where it gets a little bumpy, but first I'm going to talk about just one really unsavory thing that John Pryor said. Then we're going to jump into the DNA evidence, and then we're going to get to the tough stuff. Okay, I'm just going to play this.
Now, I'm not going to pick on the state today to everybody's surprise, but quite frankly, Judge, receiving that technical data is going to take some time.
Okay, so this might be a little petty on my part. Again, I just found this in really poor taste to say like, oh, I'm not going to pick on the state today, which, to everyone's surprise, it's like he seems to view himself as like Biff when in actuality he's McFly, I don't want to be disrespectful, but I am going to be a little disrespectful just because he's just such a dork, he's like the kid who requires everyone to wear like a dress shirt and tie to his birthday party and then screams and cries because no one came to his birthday party. He's just such a weirdo. But then, he presents himself like he's all bulked out and I'm like, you know what? Hey, it's your lucky day, state. I'm not going to pick on you today. I just thought that's in poor taste. Anyway, but I find most of the things that he says are in poor taste. And, the unfortunate thing is there are times where when he's just clamoring on about, these different injustices and how, life is just so unfair to him. And, he always tries to make it sound like the state was like, oh, yeah, by the way, sorry about that. It's a lot of information, just getting it to you in February, when in actuality, they got it to him in October, which is well before the discovery deadline. And, all that stuff. I mean, he's constantly trying to make it sound like the state is admitting fault and just like, oh, mea culpa, we should have gotten this to you sooner. I know it's a lot of data. It'll probably take at least a week and a half, to download and stuff. But anyway, but you can see from this comment, he views himself as like some big tough guy. Okay. All right. That's as petty as I'm going to get. It's going to be the only good thing to me about these cases being severed is we just have a stay of execution from having to listen to him drone on ad infinitum. Okay, because I have, as I mentioned earlier, I just find listening to Jim Archibald just a treat. Okay. All right, so let's jump into the DNA evidence. I thought it was interesting that Lindsay Blake made the point that the state didn't want to run DNA tests on the additional hairs that were found in, it sounds like they were actually found in November. I thought it was December, but we'll get to that. Her timeline is a little confusing. But we'll talk more about that. But I thought it was interesting that she made the point of like, hey, well, we didn't even want to run DNA on these hairs.
By the state's own admission, their lab and their expert located this.
Oh, let me see. Looks like maybe I didn't include that. Let me see. No. Okay. Well, I don't have, oh no, that's right. We already talked about, we already talked about that. The prior could have gotten the DNA testing done. She did circle back on it again in this hearing, but it's a little repetitive, a little redundant, so we won't touch on that. So prior made the point that there was a month delay in between the time that they found out about the additional evidence and the time that they notified him. So let's listen to that.
By the state's own admission, their lab and their expert located this evidence in November of 2022. I was informed of this new evidence in December. So for a month, after they find it, and this is the state's own timeline, in November, they find this evidence, or their expert finds this evidence. They notify the state of this evidence a month later.
Okay, so on this point, I'm not sure what to think because I've listened to this one segment from Lindsay Blake several times, and I can't quite make out what exactly the timeline was. One of the reasons is that there are at least a couple times, maybe 3, where she catches herself from saying discovered and changes it to located. So I thought the new evidence was found or was discovered in December. At some point, one of them said right before Christmas. And that was in another hearing. So I just kind of like had that pin in my mind that it was like just days before Christmas. But when she's talking about the timeline, she's talking about it being located instead of discovered. So I'll just play it.
With regard to the DNA evidence, which seems and appears to be the bulk of the current argument set for today. I know now there's been some additional argument raised, but the court already has a history of that particular evidence. That's the issue of the discussion today. But I think given statements by counsel, it may be important to reiterate some of the timeline with that particular evidence. That particular evidence was discovered or was located, in conjunction with some consumptive testing. The reason that's important is we had some evidence that was located at the state lab very early on. In this case, it was actually the point of some discussion, again, in the prior proceedings that preceded the cases in question that are before the court today. Because it was consumptive testing, we needed to wait to get some kind of an agreement or an order from the court. Due to the stay in Miss Vallow, on Miss Vallow's side of the case, we were unable to get that consumptive testing order ultimately entered until August of 2022. So before August of this year, the consumptive testing could not take place.
Now, I will stop there. That struck me as curious. Like, I was really trying to, follow this timeline with my own timeline and going through some of the filings during this time, looking at when Lori was found incompetent to stand trial, and then when her competency was restored. I think that was April 2022. And so it already kind of jumped out at me like, okay, so her competency was restored in April, but then they didn't have the hearing about the DNA until August. And so I think it was during this time, I don't have this in my notes, but I think that's when there was a lot of talk about, and hearings about the trial moving to Ada County. So I'm sure that, averted some of their efforts to try to keep the trial in, Madison, Fremont County. But yeah, so, but then as you'll see, like I was like going through, okay, well, there's April 22, then August 22, and then apparently these additional hairs were found in November, but then there is a month gap that I can't account for, and I think that's part of the reason she corrects discovered to located. So maybe there was a finding or an email or, a piece of mail that was sent to them and they didn't see it right away. I don't know. I don't know, why, what the implications are of why located is a better word than discovered. But then, as you'll see, Judge Boyce kind of blows it all out of the water. So, okay, let's finish this.
Once we received that order in August, the problem was the evidence in question that was going to be tested, that was consumptive, the evidence in question that linked to the first consumptive order, I guess to clarify, was not in the state lab's possession. It had been sent back east to another lab for additional testing. That was done by stipulation of the parties. The parties would have known that it was back there. So the state lab had to wait for that evidence to come back for them to perform the consumptive testing. That didn't come back until approximately November 10th. We received the report from the other lab on approximately October 31st. So on November 10th, when that came back, then the state lab was able to be in possession of it to complete the consumptive testing. It's my understanding the lab tech completed that about November 19th. Excuse me, Your Honor, the evidence was set back pursuant to a warrant for testing to the lab back east, but it was not in the state's possession at that time to complete the consumptive testing. When it was returned on November 10th, the lab then was able to get the testing. The initial consumptive testing was performed approximately November 19th. At that time, the additional evidence that's the subject of the current pending motion was located by the state lab. The particular evidence that we're talking about today was not believed to actually have any evidentiary value by the state lab. However, it had the possibility of being tested, and because of that, they collected that evidence at that time. Again, the problem was they could not proceed with the testing because the testing on that particular evidence would be consumptive. Defense counsel was notified as soon as the state was aware of the discovery of this, or not discovery, but the location of this new evidence. Again, we had to wait to get an agreement for consumptive testing. Once we were able to get, the testing was completed in December, we were not able to get that agreement and get an order signed until January 9th. So on January 12th, the state lab received that order for consumptive testing on that newly discovered or newly located evidence, and that testing was completed approximately on July 18th, and then they had to wait for the report to be approved, and once that was approved, we were able to get that and then give a copy to defense counsel.
Okay, so that was a long, winding road. Again, I was trying to follow all of it, but kept getting tripped up over that detail of, discovered versus located. And then this was toward the end of this particular hearing, but I'm going to play it now because it really weighs in to this.
The court has to go back and look at the factors of speedy trial, which have been brought up today, and under the Barco versus Wingo factors, there's 4 factors there the court looks at: the length of the delay, the reason for the delay, when a defendant asserted the right, and prejudice to the defendant. It's clear that in this case, the right was asserted from the beginning. She's never equivocated on that. The reason for the delay, again, without laying personal blame on anyone, it's the state's evidence that was gathered in 2020 and has gone through different stipulations, issues about whether it would be...
Oops. I'll rewind that a little bit. This is what I mean by he kind of blows it all the water. I mean, he brings it back to the state has had this evidence since 2020. I'll rewind it.
Stipulations, issues about whether it would be consumptive or not. But the reality is, just very recently here, this evidence now has been discovered that can be additionally tested. And the reason for delay there has to be attributed to the state in that case.
Okay, so, so here I was like trying to kind of strain at gnats, to figure out what this timeline was. And I thought, man, I wish I would have listened to the rest of the hearing because he brought it back to, at the end of the day, this evidence has been in the state's possession since 2020. And so they were kind of quibbling over like November and December of 2022. And anyway, so, okay. All right, John Pryor makes the point that he disagrees with the state's conclusion about the DNA evidence. The state's conclusion was that it's not of any evidentiary value, that they most likely will not be able to extract a DNA profile from it. And this is how he counters it.
And frankly, Judge, my gut belief is that we're going to come up with a little bit of a different conclusion than what the state's going to recommend, or the state's documents represent. Now, I'm not an expert, but at least on a cursory view of this evidence, it seems to suggest something other than what the state's representing. So at this point, Judge, I'm going to renew my motion to sever and ask the court to please allow us to have an opportunity to conduct that further investigation.
He also asserts that he believes the DNA evidence could have a profound impact on his case.
But when you're talking about DNA evidence, that's a whole different item. That is something that takes a significant amount of time and a significant amount of effort to evaluate. And this could have a profound impact on this case. This isn't just an insignificant piece of information.
Okay, and I thought this point was interesting. Judge Boyce talked about two types of DNA testing. He was making this point to counter Lindsay Blake's point about there not being any evidentiary value. So essentially, the state's position was, this isn't worthy of severing the cases because these experts have said most likely they're not going to be able to get a profile from them.
There's two types of testing that can be done, the STR and the genealogical testing. Isn't it true that one of them may well develop additional information? There's a higher likelihood of the genealogical testing.
That is correct, Your Honor. The STR testing, at least from the state's conversation with the current lab that has it, is the likelihood of that resulting in any profile would be extremely rare, and it would consume the entire sample. Mind you, what the state had done was not consumptive testing either. Those extracts still exist and are available for testing. The genealogical or ancestral could result in some kind of a profile, but that would simply let us know who the person was related to. And based on this particular type of evidence and how it's transferred about in the environments, the likelihood based on both the lab's assessment and both the state lab and the second lab's assessment is it would have an extremely low probability of resulting in any kind of truly evidentiary, having any true evidentiary value.
Okay, this next video snippet is Judge Boyce. This is the first time that he throws out the suggestion of severing the cases.
And so I think when we look at this particular evidence, the defense isn't without a remedy as it sits now, and arguably there could be an argument that they sit in a better position now than they could with additional testing, given the fact that we have some DNA evidence that has an unknown source. The defense can still argue that. Presumably they would argue that that is exculpatory evidence. The state would not agree with that assessment and would not concede that this is exculpatory evidence because we simply don't know at this point.
Isn't the best remedy really to sever here, to allow time for the testing so we don't have to delve into all this speculation about what this evidence is?
Okay. All right, so now we're going to wrap up talking about the issue of additional discovery. So the first mention that there was additional discovery was early on in the hearing, and I'll play that and then we'll talk about a little bit.
The court, in reviewing the file, it also appears there was an additional discovery disclosure that was filed by the state on February 27th. I don't know if any of that goes into any argument that would be scheduled for today, but that's the other development that's occurred since our hearing on Monday.
Okay, so let me give like 100-foot view here before we get into the video snippets. So the pretrial conference was held on February 27th, and all of the discovery disclosures were supposed to be in before the pretrial hearing, so by February 26th. So they had this hearing the morning of the 27th, and then I think around 4 p.m. that day, so later in the day after the pretrial conference, the state submitted additional discovery, and we'll hear from Jim Archibald just how significant this just the sheer volume of the discovery was. But that's going to be at the heart of the issue, is that all discovery was supposed to be in before the pretrial conference, and the state submitted a significant amount of discovery later that day. And they didn't mention in the pretrial conference that they would be submitting additional discovery later that day. So I don't know if they had overlooked it, didn't realize that there was discovery that hadn't been turned over. But one thing I will say at the outset, just kind of circling back on what I said in the beginning of the live, I mean, I really try to be fair, so I'm not going to withhold this information. But at the same time, like I had to work through it even in my own mind, because it was surprising. And when you hear some of the details, it is surprising, given just the gravitas of this being a capital case. But this weekend, I was just kind of working through it in my mind, and I don't say this as a sycophant, like I'm not trying to kiss up to the state. Like I'm never going to see any of these people again after this trial. So, I'm just going to represent the facts as best as possible. But I will say that, just working through it on my own, and these are people. People make mistakes. I make mistakes in my job. I miss data. I have to, circle back with clients. Hey, miss a deadline, or, something like that. So, we've all encountered, if we're in the professional field, we've all encountered that at different times. There are also a number of factors that were really kind of non-standard. Like, I followed a lot of true crime before this case, and there were factors that, were just really bizarre. Like, one, we had a pandemic. Like, there's never been a pandemic, to my knowledge, in my lifetime, and I'm not a spring chick. We also had, a member of the defense team trying his case in the media, on Twitter. He was just out of control, and then tried to have the prosecutor disqualified from the case. So, Rob Wood had to hire an attorney and deal with all of that. And Summer Shiflett obviously played a role in that. And And then, then it became a capital case. And then there was this push to move the trial to Ada County. Now that happens quite a bit in really big cases like this. But it's still like they've had a lot of plates to keep spinning. And then even when Jim Archibald joined the case, I think like early on, like there was some talk about how and I don't know if this is true, but like Mark Means wasn't sharing some of the discovery with Jim Archibald, so then he had to request it. And there were just a lot. I mean, this was a clown car, and so there were a lot of moving parts, and it sounds like some plates just kind of crashed to the floor. But the last thing I'll say before we delve into the details is, regardless of what happens with this case, even if like absolute worst case scenario, which I do not believe will happen, because if you were following this case during the time of Chad's pretrial hearing, I mean, the state presented so much evidence. I was like, wow, like it sounds like they could win this case just on what they presented in the preliminary hearing. And obviously all of the evidence that they presented in the preliminary hearing will be included in this hearing. But even though there does appear to be a preponderance of evidence that will potentially be excluded, that's the big question mark at this time. But in my opinion, aside from the victims who ultimately lost their lives and the people who loved them, the people investigating this case and litigating this case, the fact that they have had to dig through the horrific details, the minutia, like details that will never make it into the trial, because they have to present this case in such a way that, jurors can understand it. So they're not going to be able to include all of it, but they had to go through all of it. And so, in my mind, even if the worst possible scenario happened, either of these clowns, were found innocent, these people, and I do not believe that will happen, but even if it did, like the people who have investigated this case and are in the process of litigating it, they will never be the same. Like they will always walk with a limp, because just from the small amount that we have had access to, and I've read every page of those FOIA docs, and there are grisly details in the FOIA docs. And if you were following the case when the children's remains were found, the East Idaho News had a helicopter. Well, East Idaho News combined with Dateline had a helicopter, and there were images from that surveillance that were deeply, deeply disturbing. And I wasn't there. Like I didn't smell what they smelled. I didn't see everything that they saw. And so anyway, so I'm just going to put my stake in the ground that though, some of these details are disappointing, and it's not to be a sycophant, I have the deepest admiration for those who have investigated this case and are litigating it in Idaho. Arizona, not so much, but Idaho, absolutely. Okay, so moving ahead. All right, so Lindsay had said that they thought that the deadline was the February 27th, and Judge Boyce had made the point that he actually read the I forget what the scheduling order, and explained that obviously everything needed to be in before the pretrial conference. That wasn't obvious to me, but and he didn't say obviously, but that was his point. Okay, so Jim Archibald talked more about the details of what was in this discovery disclosure.
And so when the government holds evidence and refuses to turn it over, either because they're playing cute or they're playing ignorant, as Mr. Pryor has argued, that the responsibility still is on them. And so, similarly to the DNA evidence, this disclosure this week is really disappointing to me as well. That we were here in court Monday. They could have handed me this supplemental discovery disclosure when we were here in court, but no, they filed it after our hearing. I didn't get the flash drive until Tuesday, and I still haven't gone through all of it. It's 10 pages of items, 10 pages that's listing out hundreds of interviews and exhibits that we have not seen yet.
Okay, so the summary there is this discovery disclosure was 10 pages representing hundreds of interviews and exhibits. So not hundreds of interviews and exhibits that the defense hadn't seen. Now, I will kind of circle back to something that Tawnya Rawlings, so she was an attorney who spoke pretty briefly for the state on February 27th. So when Jim Archibald talked about how, they were at court on Monday, that was February 27th. And so on February 27th, Ms. Rawlings talked about some corrupted files, and every once in a while there will be a detail that I'm like, that captures my attention because it reminds me of something else. So let's listen to what she has to say, and then I will address this.
It's a little bit frustrating, Your Honor, to try and go through, and I fully empathize with defense counsel in terms of going through the vast amounts of discovery. I myself am late to this case. I have not been appointed on it for a lengthy period of time, and I recognize that there is a vast amount of evidence. The state, in an effort to make sure that everything we have turned over previously, has been going through discovery since probably November, going through things and making sure that everything that we have turned over was correct and they're not corrupted. We've had problems, I think, with corrupted files that were discovered after they'd been turned over, and this information
just tuck that away, this point about corrupted files.
After they'd been turned over, and this information just wasn't known to the state. There were a few things in addition, I think, that we thought had been copied over from different law enforcement agencies, and then were not. For whatever reason, they just didn't copy over into our cloud discovery file. So we've been going back through everything to make sure that everything that we have supplied to this point is actually there, and that is the reason there have been some recent further disclosures, because we discovered, in an effort to try and be diligent and make sure that everything that we have is turned over and is uncorrupted, we discovered that there were some items that hadn't copied over or that the files had become corrupted.
So when she mentioned corrupted files, I thought back to Mark Means' third motion to compel. I believe this was from August 2021. He had submitted this, and the reason it was very fresh in my mind is that there were references to a lot of interviews and dates to interviews. So basically, And let me back up a little bit. I was asking my friend who's a judge about, what exactly is meant by, these like supplemental discovery disclosures, like what makes them supplemental. And she explained that. I won't get into all the minutia of what that means. But like the defense can ask for discovery, and she said a lot of times they'll find out about items that should be included in the discovery from interviews or references to, let's say, an interview or a piece of evidence that's mentioned elsewhere. And I said, oh, well, that is exactly what happened with this motion to compel. Because, and we won't go too much into it, but I think, and I don't even know that these were the interviews that weren't included, prior to February 27th. That we don't know. We don't know what those interviews were. I know at one point, I'm just thinking of this on the fly, from a conversation I had with Janice this week about this, that Lindsay had said the most important, I think, interviews and details the state did pass on, and Judge Boyce had something to say about that. But so I just don't know if this motion to compel, all the interviews that were mentioned in here were the items that were left out. But he talks in this filing about, hey, basically, there were quite a few references to damaged or corrupted documents. So I can explain a little bit about that because it's pretty common to have a PDF as an export option from a number of tools that I work with, even something as simple as Microsoft Word. You could take a Word file and you can export it to PDF. Well, sometimes in that export process, the PDF is corrupted. Maybe they closed out of the file too fast, or just, something went wrong. But also files can get corrupted when they're being uploaded. So maybe there's a hiccup in the connection in the Wi-Fi, or there's the memory issue that can cause issues. I mean, any number of things can cause these files to be corrupted, and it does require a bit of due diligence to then, actually open the file. I don't know how their particular system works, but a lot of these, cloud-based file systems work very similarly. So when you upload it, you can then open it and make sure that it opens. And it sounds like when some of these files were uploaded, either they didn't test them before they uploaded them, or they didn't test them after they uploaded, or both, because they were corrupted. There were also missing interviews. So Mark Means talks about, hey, there was a reference to, I think Regan Price was a neighbor who also mentioned something about talking to Rob Wood. And so he was like, we don't have the interview with Rob Wood. I think it was Regan Price. And there was also something with, Melanie Gibb and stuff. So there were quite a few missing videos. There were some where the video was missing. There was only summary notes, and sometimes there was the video, but it didn't include the transcript, and there were just a number of details. So when she made the point about discovering that there were corrupted files, whether it was these or not, I was like, oh, okay, well, I think that this is probably an ongoing issue with the state, and it's just a vulnerability that they need to ratchet down on, to make sure hopefully for the future, that everything is uploaded. And and so much of this, it just comes down to project management. I don't say that like in an accusatory way. Like I said, I have made all of these mistakes in my own business, but I'm not a prosecutor prosecuting a case like this. So typically my mistakes are pretty easy to rectify. But anyway, so it sparked my memory just because I had spent so much time, teasing out all of the dates. Like, he would say, okay, October 20th, 2020, there was an interview with Melanie Gibb, clearly identifies prior conversation with Mr. Wood in this interview, yada, yada, yada. But anyway, so I was going through these and like, oh, word? Okay, there was an interview with Melanie Gibb on October 20th. So I would add these points to the timeline. Okay. This was Judge Boyce's response to the late discovery.
Let me just raise a point or two here, Ms. Blake. First of all, on the argument that they got the bulk of the evidence, these are capital charges. Is the defense not entitled to all of the evidence? If it's relevant enough to be listed in discovery disclosures from the state, I mean, as far as I know, they get all the evidence. They don't get the bulk or the majority of the evidence. Would you agree with that as a general proposition in a capital case?
Yes, Your Honor, and I would agree with that as a proposition in any criminal case.
Okay, and secondly, this latest new disclosure, which, according to Mr. Archibald, is voluminous. The issue I've got there, and we're going to hear this, as he mentioned, in another motion, in another hearing before trial, our court's scheduling order, which was issued last December, gave a deadline for completion of discovery prior to February 27th. So this, although it's a day late, it's late under the scheduling order. All discovery must be completed prior to February 27th, 2023, and the notice of the new filing of the discovery filed in the case at 4:03 on the 27th, so it's late under the court's scheduling order. Again, I've presided over a lot of cases. I know how things get hectic when we're getting close to trial. This is a capital case. The indication today that there's a voluminous amount of new discovery just being handed over after the scheduling order deadline, I'll tell you, it's extremely concerning for the court, and I see Mr. Archibald's notable frustration here of having this evidence now delivered past the deadline that we had all known about for some time.
So when he said, I mean, there were a couple of things. One, I really like how he leads with questions. I mean, obviously they're leading questions, but I like how he addresses the seriousness of this situation, but doesn't do it, in my opinion, in an accusatory manner. And but when he said it's extremely concerning for the court, because he's not a big reactor, and he doesn't, get on a soapbox like John Pryor, that did pack a pretty powerful punch. Also, take note at the end how he draws attention to Jim Archibald's, like notable or visible or, whatever, frustration. In my opinion, he would never do that with John Pryor because he's frustrated about everything. And so I do hope that John Pryor, watches this case, watches this, this trial closely and learns from Jim Archibald, because I think for him to even wage an effective defense, he's going to have to tamp down his emotion level, because it's going to be exhausting, for everyone involved, including the jury. And I just don't think it will bode well for Chad at all. But anyway, so yeah, that was where he made the point. Although, it's a day late, it's late. Okay. Yeah, I'm going to skip ahead to this point, because this is where Jim Archibald talks about, how he's going to address this.
And so I have to file now a motion in limine to exclude all of this evidence that they gave to me 2 days ago. I now have to set another hearing. We now have to annoy the court with more motions to exclude evidence, because they've been sitting on it. There's witnesses and interviews here from the FBI in 2020, and I just get it now? I'm just really disappointed.
So his reference to interviews from 2020, again, it's just a question in the back of my mind. Are those interviews from that are referenced in Mark Means' motion to compel? And just by way of reminder, or if you weren't following the case at that time, so he submitted that in August of 2021, but Lori had just recently been declared incompetent to stand trial. So her case was stayed, and Jim Archibald joined the case right around the time of this motion, like either right before or right after, and then John Thomas was added. I think his first name is John, but he was added a little later in 2021. And then I believe in December of 2021, Mark Means was disqualified, and Lori hadn't been declared competent. Her competency wasn't restored, I should say, until April 2022. So Mark Means kind of went away. And at that time, he was even calling for, sanctions, and because, he expressed quite a bit of frustration about, he drove to Fremont County to pick up this evidence, and according to him, he was given the runaround. Again, this is where because he also was very, very emotional, very much like John Pryor. I mean, I think both of them, they just wear their emotions on their sleeve, and they just just vomit out all of this emotion, and it makes it very hard to to get to winnow through all of the noise to find the signal. So I do wonder, and again, I could be totally wrong. We don't know what what this evidence was and what these interviews were. I did think it was notable, though, that he mentioned the FBI. The FBI is mentioned in Mark Means' motion to compel. I'll share a link to all of these videos and all of the filings that I've shared. In fact, I scheduled it to go out on in Cool Cats and on the community tab at 9:30, but I need to update them because there were a couple of videos that I created after creating that link. So I'll update it either tonight or tomorrow morning so that, those of you who are hardcore, you can, go through these and reference them. I tried to make the file names as descriptive as possible, to that end. But, okay. But in that filing, he did mention the FBI at least twice. So maybe not. But the most notable thing here is that Jim Archibald had said that he is going to file a motion in limine to exclude all of the evidence that was handed over late. So this was the main question I had asked my friend about, and she had all kinds of caveats about being minimally aware of the case and all of that. So take this with somewhat of a grain of salt. But she said in this case, it puts the judge in a difficult position, but because he's going to have to make a ruling on this evidence. And so she said the judge has to look at what she called balance of harm. Like, which ruling creates a more appealable issue. She said in general, this creates an appealable issue. If the judge decides that, the evidence should be allowed, with a note, like you can't do this again. My friend didn't say that. I'm adding that in. If the judge decides to allow the evidence, then that's, room for a possible appeal because, evidence, and especially because it was a preponderance of evidence, according to Jim Archibald, who isn't really given to hyperbole. Again, if this had been John Pryor, I think it would have been a lot harder. And that's why I suspect that John Pryor kind of gave that hat tip in the beginning, like, oh, I'm not going to pick on the state because, he didn't really have a whole lot to say about this. But I think that I think that there's a possibility that they decided to let Jim Archibald take this ball and carry it downfield. But so, so the judge is going to have to decide if this evidence should be admitted. I just don't, I don't get into predictions. I actually resent them. I stopped following the attorneys who were shedding light on this case just because this is just my personal opinion. And of course, mine is, going to be impacted somewhat by personality and also somewhat by being a family member. And also I just despise unnecessary hysteria. And so I feel like some of the people who have been really helpful in explaining the law, they focus so much on predictions that I just can't listen to them anymore because they predict things and then they're wrong or even if they're right, I'm like, who cares? We'll find out what's going to happen, but it just comes across a little too Donna Serafina-ish to me, too psychic, whoa, I'm predicting. I remember one of them who I, had relied on pretty heavily predicted that Lori was still going to be found incompetent to stand trial, and then her competency was restored. And that's when I stopped listening to him because I was just like, I'm just so tired of this. Because of course they never circle back and say, oh, okay, well, I was wrong about that. You win some, you lose some. So I'm not going to weigh in on the prediction. And my friend and I were actually not in agreement on how this will most likely go. But what is at stake is this evidence. And what she said is that any information that they gathered from these interviews will not be able to be admitted as evidence if it is excluded. So, okay. And if it's not excluded, it could force her counsel to, to really try to compel her to give up her right to a speedy trial. So, all right. Jim Archibald talked about how I thought that this was interesting, but kind of in an almost pathetic way. Like he almost sounds pining in this, but he makes the point that he consistently talks with her about speedy trial and about waiving speedy trial. Here's what he has to say.
Your Honor, we're disappointed that the state held on to this evidence for so long without notifying the two defendants here of the evidence against them. Disappointed that they thought that they could be the sole judge of what's exculpatory and what's inculpatory. So this evidence has been held by the state for undue periods of time, and that's what finds us here. That's what finds Mr. Pryor asking for more time. If my client waived speedy trial, I would also be asking for more time.
And here he talks about how it comes up frequently.
Every day that I visit with my client, we talk about her right to a speedy trial. It is important to her. We filed a motion. The court has made a decision, and it's something that we'll continue to talk about. If these cases are severed today, then we'll continue to talk about speedy trial. And so I don't think that this late disclosure of DNA evidence justifies taking away my client's right to a speedy trial.
Now, toward the very end, I'm going to include this just because it was out of character for Jim Archibald. I think that's why, I don't know, maybe this is why Judge Boyce gave him this latitude, because, there are protocols, like the one side will speak, the other one will, will address their issues with that, and sometimes the judge will give them additional opportunity to weigh in on something. But in this case, Jim Archibald spoke out of turn, and it was almost a mic drop. I think at this point he was upset, and I think he kind of went to do a mic drop, but fumbled the mic a little bit, because in my opinion, what he said didn't really make sense, but his use of an SAT word was very impressive. But we'll just listen to it, and then I'll talk about it.
Your Honor, I think the state had addressed our thoughts with regard to speedy trial. I think under the current case law, the court could find good cause for the delay. Again, if there's good cause to continue Mr. Daybell's case, I think there would be good cause to consider Ms. Vallow's side of things, especially given her defense counsel's representation that they believe that evidence should also be tested and could hold value. It would seem that there would be good cause to continue hers out. Again, I think it could be continued in such a manner that we didn't go too far past where we're currently set.
Your Honor, there's no way that I'm conceding what she just said. There's no way I'm conceding that. She's not going to blame their dilatory tactics on me.
Okay. That'll conclude then the argument on pending motions. I'm going to take a few moments to review those arguments. I'm prepared to make some rulings today from the bench. Let's take a recess. I'm going to say about 20 minutes, so maybe shortly before 10:30, we'll come back on the bench, and the court's prepared to make rulings at this time. So we will take that recess now.
Okay, so what Lindsay Blake was saying was basically like, hey, this could be kind of a win-win, like if the court decides that, that Chad's team should have more time to examine the evidence. This could also be good for Lori to give, her counsel also more time to examine the DNA evidence. And I think what Jim Archibald was trying to say, I loved his use of the word dilatory. As a word nerd, I was like, oh, plus 10. But I think what he was trying to say was, or maybe what he would have said, in retrospect, was he's not going to allow, Ms. Blake to present this as a win-win. Like his point was these are dilatory tactics. In other words, like he's trying to make the case that the state intentionally withheld this evidence until the last minute. Judge Boyce addresses that, and I very much agree with his position on this. So I think he was trying to say this isn't a win-win, but ended up saying like she's not going to blame it on me, but she wasn't blaming it on him. She was, in my opinion, unless I'm misinterpreting it, she was presenting it more as like, hey, maybe we could all win from this. But you'll see that, Boyce, Judge Boyce, he didn't push back. It wasn't Jim Archibald's turn to talk. He had already had his chance to present his case. But I think it was latitude that Judge Boyce was willing to give him, because I think Judge Boyce, I wasn't there. This is where it is a disadvantage that you can't, for some of these things, you can't see the people's faces and kind of read body language and stuff. But even from what you could hear and what Judge Boyce said, he was clearly very empathetic toward Jim Archibald in this particular hearing. Okay, this is what Judge Boyce had to say about the delay and the prosecutors. Oops, sorry.
At this point, there's been a renewed motion to sever, and it ties directly into this DNA evidence. The timeframes, again, are important here for the court to consider. I don't find that there's been any Brady violations as have been asserted in the motion to sever.
So the Brady violations, that was brought by John Pryor because, everything has to be like the worst case scenario. And so that's why he said that. We didn't have any video snippets where he was going on and on about the Brady violations.
And also, I'll note explicitly on the record that I know and work with these prosecutors on a regular basis, and I don't believe that in any way they have either intentionally or strategically delayed the disclosure of any evidence in this case.
So, and then I cut it off there just because there was no natural cutoff after this point, because then he went into a very long explanation for why he, ultimately decided to sever the cases for whatever it's worth. I agree with his decision. Ultimately, it came down to, if I could summarize, I think it was like 8 minutes of explanation. He talked about, having a concern about a potential mistrial, or I think he said, or the possibilities of convictions being vacated or overturned. We'll just listen to it. I think he said vacated, but I just pulled out that short snippet.
What I'm absolutely not willing to do is engage in any speculation about what this new DNA evidence may end up revealing. If we were to just roll the dice and go to trial and have this continue to be tested and find out later on, well, it really wasn't anything, then we'd be okay. If we find out later on or during trial, well, it was something. What do we have then, a mistrial? Do we have convictions that have to be vacated because of this new evidence that we knew about before trial started?
Okay. So, again, for what it's worth, I agree with him on all points. I absolutely do not agree with Jim Archibald that this was strategic on the part of the state. I imagine there was quite a bit of panic when they realized that this discovery hadn't been turned over, that some of these corrupted files hadn't been fixed, or even that they were corrupted. We've also had, some like new people being added to the case. So it's not like the prosecution had a consistent staff throughout the entirety of this case. It was a mistake that was made somewhere along the line. But again, I was muted. Okay. Yeah. So, sorry about that. I'm just going to open it up for Q&A. If you have any questions, please just put the word question in all caps. Excuse me. I think the only point that I had made is that I think I might have been muted for was just that, like Janice had pointed out this week, that Jim Archibald has been a defense attorney for a long time. Now, John Pryor said that he's been a defense attorney for 26 years. So he just doesn't come across as experienced as Jim Archibald, but, maybe so. Maybe he just mostly, represented much smaller cases. I don't know. But that the point that she had made is that, he's been a defense attorney much, much longer than Rob Wood or Lindsay Blake have been prosecutors, and so even if you're really experienced at something, mistakes still happen. Like people make mistakes, and I don't say this in a patronizing, kind of way, but anyway, I just thought that was an interesting point because I didn't really have that piece of the puzzle, like just how many years experience Jim Archibald has had being a defense attorney. Oh, Nola V said he was also a judge. I didn't know, or I think I might have heard that at some point. Jeez. I'm not going to repeat that. Okay. Now all I hear it. Now all I read is no sound. But yeah, so if you have any questions, again, just put question in all caps. If not, we will wrap up. Yeah, Leah, I agree with that statement, although I would drop the unfortunately, personally. She does, I believe she does have a great defense attorney in Jim Archibald. I think he has I just think he has a really nice combination. It was a little cringy when he, it was so accusatory toward the prosecution, but it also makes sense that he would be, kind of more emotional about this issue, feel like, somewhat betrayed or, surprised or whatever, and under stress if all of this additional discovery is actually, allowed in the trial. And also, he still is a defense attorney, and he doesn't overplay his hand in, being really upset. So I was like, okay, well, that was his move. I'll give him that. Anna, hi Anna. She asked, do you think Lori will waive speedy trial now that the case is severed? That's a really good question. Again, I'm not really big on predictions. And also she's just so mercurial, like I described it one time to like, it's kind of like, like predicting her next move, especially when she was represented by Mark Means, because they were both given to hysteria, and, so, it was like you're watching, it felt like you'd be watching a chess game, and then suddenly, the person just like picks up the board and starts eating it, like it makes it very, very challenging to, to anticipate what any of their next moves will be, except Jim Archibald. I think his moves are a little more predictable, as are Judge Boyce's, in my opinion. But, I still could be surprised. So, there is a part of me that thinks like, well, I can't imagine her giving up the opportunity to get to see Chad every day for weeks. And it's also a curious thing to me why she has held on to her speedy trial right so strongly. Like my friend who's a judge, she said, well, the speedy trial, this could be strategy on her attorney's part, and she listed a couple of different reasons. I was like, I don't really think so, because that's why I included the detail of, about like they talk about potentially waiving her speedy trial rights every time he visits with her. So, and he just came right out and said, if my client would waive speedy trial, I also would be asking for more time. So I'm not exactly sure what is compelling her to not waive speedy trial. But I do wonder, because she is such a narcissist, I do wonder if she's concerned that by the time this goes to trial, people will kind of forget her, because, there was that story from someone who shared, I don't think she shared a cell. I think she shared, like she was in the same area as Lori, I think one of the shows, like a Dateline or something, was on, and she said Lori was like, oh, or no, it was a court hearing, and she wanted to watch it, and she wanted her new friend to watch it with her. She was excited about, this being on television. So there could be some of that. But also being as extroverted as she is, who knows, like the isolation might really be kind of eating at her, because, she has been largely isolated for 3 years. And, I don't think she probably has that much of a clue into how tough the state prisons are for women. I only know from people who live in the area that they're pretty tough, and so so I don't know what is driving it, and so because of that, I just can't predict. I mean, even in my own mind, like there are some things I do predict in my mind, but I'm not going to share them because I just hate the prediction game. But in this one, I really I would slightly lean a little bit more toward her not waiving her speedy trial, right? Just out of like stubbornness. But yeah, I don't know. But, and one other possibility is if she really is under the delusion that somehow God or Moroni or, whoever she thinks, helped her justify these actions, if she believes that, like they're going to defend her and see to it that she's not found guilty, then that would also help explain why she won't waive speedy trial, because she could legitimately be under the delusion that she's going to be found not guilty. Okay. Wow. Melanie Avery said Jim Archibald dated her roommate in college in 1980. Interesting. Okay. Yeah, the question at Cat 73, the question always comes up of like if one of them will flip on the other. I think the fact that they haven't yet, to me, and I've talked about this in other lives, I do suspect that it would be a zero-sum game for them. Like if they know each other's worst secrets, meaning if they murdered before, if they plan to murder before, and then it just, at this point now they're facing the possibility of the death penalty. But if they flipped on each other and they started going after each other, they'd probably almost certainly face the death penalty, unless the prosecution offered one of them just an amazing deal. And I don't think for Lori, life in prison would do it, because I don't think she has a lot of fear of dying. Okay. Just looking to see if there are any other questions. All right, I'm going to take one more scroll and nope. Okay. All right. I'm going to wrap up with that. Like I said, I will update the link with all of the videos. There were just two that, as I was preparing tonight, I was like, oh, I should go and find that snippet and add it. But anyway, thanks for joining me tonight. If you have any questions that I didn't see or didn't get to, please feel free to drop them. But in the below the video, like I said, I do check somewhat regularly and try to answer those questions, and I'll get pretty detailed in those questions. We've had a lot of questions about some of the material I've shared so far, and we're still going to be on track for Friday nights live to get back to the timeline. But I will go in and like create screenshots, and some of the ridiculous questions I'm just going to ignore or ban the people. Like we have had fairly minimal troll activity, although who knows. I mean, my moderators are so good at like sweeping it away, but usually before I get in there. But anyway, if you have questions, drop them below, and I'll see you Friday night.